Good morning, sir. Thank you for having me here. Today, we are going to have a conversation on a very interesting topic, that is defending an accused knowing that he has committed a heinous crime.
Good morning.
So, I have a few questions for you. So, my first question is the basic question, like why? How do you feel about defending an accused having committed a heinous crime? And is there some kind of pressure on you while doing that, or does it take a toll on your mental health? So,
That's a good question. I have to reflect on this. I have been at the bar for 3 decades now. I got designated in 2015. I have defended thousands of litigants accused of heinous offences. Long years of professional experience have taught me objectivity. By objectivity, I mean I have to prepare the brief to the best of my ability within the four corners of the law and argue the same before the court of law. So once you become objective while dealing with a brief, there is no question of any mental pressure, being imposed on my mind. Now, I don't have emotions attached with the brief. And now, by saying that I am not emotional to the brief, I don't mean to say I am indifferent. I am passionate to the brief. I must try and save the litigant. I must try and defend the accused to the best of my ability to secure an acquittal. But once I have discharged my responsibility as a counsel, that's the end of my duty. So, therefore, I repeat, there is no question of taking any mental pressure upon myself.
thank you, sir. That was quite a sterling answer. My second question to you is, how often do you know about the guilt of your client? Do you ask that from them itself, or do you get to know about that in the due course of your professional engagements?
That's a very good question. And I'm asked this question very frequently, at parties, at social platforms, and at various forums. First of all, I never ask the client, the litigant, whether he has committed the crime. Secondly, my knowledge as to whether he has committed the crime is not relevant. It is not admissible as a piece of evidence. Under the law of evidence, even if the accused was to confess to me that he has committed the crime and I was to record that conversation, that piece of evidence is a nullity. It is inadmissible in evidence. So if my knowledge is inadmissible, I don't need to get into that zone of finding out whether he has committed the crime or not. Yes, there are times when, after examining the records of the case, that I come to know that perhaps the man is guilty. But then I come back to the same principle. I have to discharge my professional duty to the best of my ability while defending the accused. Now, I must explain this to you in a different manner. The right to fair trial is a human right. The right to be defended in the court of law is a human right. It is a well established principle of criminal jurisprudence that no man shall be condemned unheard. It is a fundamental principle of criminal law that the prosecution must prove its case beyond all reasonable doubt. It is yet another principle that is well embedded in criminal law that no man shall be condemned unheard. Now, when you apply all these principles on a standalone basis and cumulatively, what emerges is this. As a counsel, I have a duty to represent the accused, and it is not my duty to get into the zone of finding out whether he is the man who is guilty. That's the duty of the court of law. That's the duty of the judge to decide whether he should be declared innocent or he should be convicted. Let me give you another angle of this. If there was a law that the accused must satisfy every lawyer that he is innocent, only then will he be represented. It will lead to chaos in the criminal justice system. You will have a litigant, you will have a double, triple trial, you will have a hierarchy of trials. We just imagine the situation that the accused is going with his file from one lawyer to the other and then trying to convince every lawyer under the sun that he is an innocent man and that he should be defended. So with all these principles in play, it is not my domain to know whether he has committed the crime or not. Even if I come to know, it is irrelevant, a nullity, and inadmissible as a piece of evidence.
Thank you, sir. That was quite a thought-provoking. So now I will talk about the Nirbhaya case. Like, I want to know your opinion that whether if you would have given a chance to fight for the accused, would you have taken that opportunity? And would it have affected your morals or ethics in any manner?
That's a good question. First of all, I must share a secret with you. When the appeals were pending in the High Court, I was being considered to represent one of the accused as an amicus. Now, this was told to me subsequently by a judge of the Delhi High Court. However, things didn't materialize. Now, coming to your question, I would definitely have defended the accused in the Nirbhaya case. That would have been my professional duty. I repeat, it is my duty to represent the accused. And I owe this duty to the accused. And again, I repeat, it is not my domain to judge whether the accused has committed the crime or not. Now, having said this, I must say that keeping in view the brutality of the crime, I am happy that the accused were convicted and sentenced to death. But see, we all have our duties to perform. As a defense counsel, my duty is to represent the accused. As a judge presiding over the criminal trial, it is his duty to adjudicate and decide whether he is innocent or guilty. Once he is declared to be guilty and sentenced to death, it is the hangman's duty to hang him until death. So we are all discharging our respective duties. Now you spoke about ethics. It is ethical to represent any accused under the sun. Let's take the case of Kasab. Now, in the Bombay High Court, in the Bombay Bar, there was a hue and cry that no lawyer should represent Kasab. Ultimately, he was given a defense counsel at state expense. Now, assuming that nobody had represented Kasab, the trial could have been vitiated. He could have been acquitted. So, before condemning any person, any accused, he has a right to be defended in the court of law. Now, insofar as ethics are concerned, as long as I am defending the accused within the four corners of the law, I am discharging my professional duty. The moment, if I was to advise the litigant, the accused, to influence the witnesses, to threaten the witnesses, now that's the unethical aspect. Now I am reminded of the BMW case, where some of the defense counsels were found to have influenced the witnesses. Now that's the unethical part. But apart from that, it is perfectly ethical to represent any accused, howsoever serious may be the allegations.
Thank you, sir. Now, coming to the conclusion of this conversation, I have a question that me, I personally wanted to ask, and many of the budding lawyers would like to know, that what characteristics make a good criminal lawyer?
That's a good question. In my view, more youngsters should come and practice on the criminal side. I see youngsters being more attracted towards business law, corporate law, etc. I want to see more vibrant youngsters taking up criminal law practice. That's one. Secondly, cross examination is a dying art in India. You hardly find good cross examiners in the criminal justice system. I feel, law colleges in their curriculums must have cross examination as a very important separate subject. So therefore, in my view, for a good criminal lawyer, he must develop the art and science of cross examination. That's my view.
Thank you, sir. This has been a quite intriguing conversation. So, thank you. And one thing that I would like to say, that your views must have inspired a lot of lawyers to take up the cases of the accused who are not given lawyers. So, that must have inspired many of us.
Thank you, thank you. It was a pleasure interacting with you, and I am always very happy interacting and discussing legal issues with the young lawyers. Thank you very much.